All right, let's get started today talking about civil liberties. I want to lay out here a definition of what are civil liberties, and then I want to talk about what institutions ultimately play a key role in defining what are civil liberties in American politics. Uh, so, um, so first, really quickly, we'll say the definition of a civil liberty are fundamental rights held by we the people against the government. All right, so civil liberties really are the same as negative liberties. I think we've talked about that from time to time. So civil liberties are negative liberties, liberties that we the people possess by dint of limiting the power of government to invade those rights and liberties. So for example, right, we'll see that the Bill of Rights captures that. Amendments 1 through 9, all of these amendments talk about Congress shall make no law, government shall not engage in unreasonable searches and seizures, shall not do unto us cruel and unusual punishments, that sort of thing. So these are rights and liberties that are achieved by limiting the power of government. And very quickly, I would distinguish that from civil rights, which often require government action to protect those rights from maybe other levels of government or maybe from we the people, right? Sometimes we the people take away the rights of other fellow citizens. That becomes the domain of civil rights. We're talking here about civil liberties or negative liberties, as defined by John Locke and then later put more felicitously by Thomas Jefferson. We are endowed by our Creator with certain unalienable rights. Among these, life, liberty, and the pursuit of property, as Locke would have it, or Jefferson, as Jefferson put it, happiness. All right, so that's a basic definition. Now, in the next set of slides here, we'll talk about which institutions define what those are in practice. All right, let's talk about those institutions that define the scope of civil liberties. But before we do that, let me just very quickly run through some basic historical facts here. Right, we know that the founders debated intensely over the need for a Bill of Rights. Ultimately, the Anti-Federalists were able to argue on behalf of such a document. It was added once the Constitution was ratified and that first Congress met. First thing they did was pass a Bill of Rights. Um, and it's premised upon, again, John Locke's argument that we are endowed by our Creator with certain fundamental unalienable rights, life, liberty, and the pursuit of happiness. As Locke also noted, if government fails to protect these liberties, these rights, then there's the right to revolution by we the people. Also remember, however, liberty does not equal license, a la John Stuart Mill. Your right to swing your fist ends where another person's nose begins. So no rights are absolute. Rights are always conditional upon other rights and other concerns, such as perhaps, we'll see, national security. Um, Also recognize, again, a la the brilliant John Stuart Mill, that threats to liberty can emanate from we the people. We the people can tyrannize other segments of we the people. Typically, majorities will tyrannize unpopular minorities or individuals. That's another way that the Bill of Rights can prevent that from happening, is to contest exactly that dynamic in a democracy. To conclude this introductory section about the Bill of Rights, let's talk briefly about how initially the Bill of Rights was understood, I think correctly, to apply only against the national government, right? If you look at those very first words of the very first amendment, they are this: Congress shall make no law respecting an establishment of religion or denying the free exercise thereof, or words to that effect, right? So Congress shall make no law. The idea then being that the Bill of Rights was designed to rein in the potentially tyrannical behavior of the national government, right? Understood not to apply against state and local governments. What were the founders most concerned about at the founding? An overly powerful national government. They knew they were creating one that was much stronger than we had had under the Articles, and so to rein in that national government, the Bill of Rights was designed to apply against the national government. The general idea was state and local governments would have their own Bill of Rights. State constitutions would contain a Bill of Rights, and that would take care of that. Well, we know, right, just from Madison, that indeed small republics are prone to engage in tyrannical behavior. If small republics are understood to include state and local governments, this becomes a problem, right? The Madisonian dilemma is most intense at the state and local level. So this becomes a problem. It begins to change, but only begins to change after the Civil War with passage of the 14th Amendment, which applies, remember, against the states. No state shall deny to any citizen equal protection of the law, shall not deny to citizens due process of law, shall not deny to citizens the privileges and immunities that are due to citizens. So we know that in a variety of ways, the 14th Amendment was designed to rein in the power of the state governments, right, vis-a-vis due process of law and the privileges and immunities of citizenship. So that starts to create some possibilities, right? Because the question becomes, what is due process? What does due process of law include? What do the privileges and immunities of citizenship encompass? Initially, sad to say, post-Civil War, the Supreme Court understood that to apply only the Fifth Amendment against state governments vis-a-vis corporations. So this meant that some of that progressive legislation in the late 19th and early 20th centuries were struck down by the court using the 14th Amendment, right, to apply the Fifth Amendment against state governments in order to protect corporations from wild and crazy things like child labor laws, minimum wage laws, maximum hour laws. But you see the potential here, right? It's important that you see the potential. Think about it, right? States cannot take away due process of law. Does due process of law include at least elements of the Bill of Rights? Okay, so we take for granted today, right, that the Bill of Rights applies against state and local government. But for a very long time, that was not the case. Because remember, that First Amendment, right, says Congress, damn it, how does it go? Congress shall pass no law regarding an establishment of religion or denying the free exercise thereof, right? So, Congress. And that was the concern, right, of those who got it passed, the anti-feds, was to limit national power. So for a good chunk of our history, the Bill of Rights had very limited application. That changes, although we didn't really quite know it at the time, with passage of the 14th Amendment after the Civil War. It says that what does it say? It says that the states cannot deny due process of law to people. What does that mean, right? Due process of law. Initially, the court said, well, it does apply the Fifth Amendment protection of property rights against state efforts to regulate corporations. Okay, so corporations initially got protection from the Fifth Amendment through the 14th Amendment's Due Process Clause. That was the beginning. And that was, by the way, pretty shameful, right? Because it meant that the court was striking down all sorts of progressive laws post-Civil War involving things like minimum wages and child labor laws and workplace safety regulations. Pretty shameful. Now, a better iteration of that is Gitlow v. New York, 1925, where the Supreme Court, for the first time, applies part of the First Amendment, the Free Speech Clause, against the state of New York. Now look, Benjamin Gitlow still goes down for inciting opposition to, I don't know, maybe, what was Gitlow in there for? Maybe for promoting Karl Marx's Communist Manifesto, something like that. So he still ended up in prison and convicted, although I think the governor ultimately pardoned him. But, important for our purposes, for the first time, the Supreme Court applied part of the Bill of Rights against the states. Okay, so the principle is there, that you're going to protect ordinary Americans from state and local government vis-a-vis the Bill of Rights. It's a beginning. It's a beginning. It's a small but important beginning. And over time, the court starts to say, oh, hey, if free speech is part of due process of law, applicable against the states, then maybe other things in the Bill of Rights are also fundamental and part of due process protected against the states, right? So they begin to expand various elements of the Bill of Rights against the states. That really picks up speed during the Warren Court years in the 1950s and 1960s, especially those first several amendments involving the rights of those accused of crime. So you get a whole lot of that through the Warren Court, right? Or Warren, right? He was Chief Justice put there by Eisenhower. He's the one, of course, right, who helped get the court to unanimity on Brown v. Board of Education in 1954. So huge props to the Warren Court in the process of selective incorporation. One of the more recent major cases incorporating part of the Bill of Rights was McDonald v. Chicago, 2010, right, the companion case to D.C. v. Heller, 2008, in which the court rules that not only is the Second Amendment an individual right applicable even absent participation in a well-regulated state militia, but it's also just an individual right that everybody has. Within boundaries, of course, right? Reasonable regulations will be upheld, but right, that broadened understanding of the Second Amendment that we get in D.C. v. Heller becomes applicable to the states in McDonald v. Chicago, 2010. An even more recent case showing you that the process of selective incorporation is not quite finished. As recently as 2019, the Supreme Court decided in Timms v. Indiana that the Eighth Amendment provision on no excessive fines applies against the states, in this case the state of Indiana. All right, so that is this critical process of selective incorporation, something that today we take totally for granted. But again, in terms of protecting ordinary people from state and local government through the Bill of Rights, that doesn't even begin to happen until 1925. It accelerates in the 1950s and 1960s under the leadership of Chief Justice Earl Warren. And, every once in a while, the court will still kick out a case that adds yet another piece of the Bill of Rights.